So, hi, I'm Joyce, CEO of Herekind, and I'm here today with Kathy Rundle from Ballantyne Law. Thank you, Kathy, for joining me today. The topic today is, we've all heard of families fighting over an inheritance, and in Australia, we're coming to a period of what we call peak death, the most amount of deaths that we've ever seen, and what comes with that is also the converse side of peak loss and this great wealth transfer, inheritance passing from the older generation to the next. Obviously, we have this incredible opportunity to build more resilient family and community systems and avoid relationship breakdowns over disputes around this wealth transfer. And so, Kathy, I would love to chat to you about your experiences, in particular what families can start to do now to prepare for the transfer of wealth and what they can do to reduce family conflict when that time comes.
All right, thanks for having me here today, Joyce. And I think what you've already alluded to is this great wealth transfer in the ageing population, and it's certainly what we're seeing as lawyers in our law firm. We've got an older population, we've got a lot more blended families, property prices across Australia are booming, and previously when estates might have been worth a couple of $100,000 because the property was purchased by mum and dad in the 50s, now worth 2-3+ million, and all of a sudden we're seeing that people are thinking, well, maybe I should get a bigger share of the estate than my brother or my sister or mum or dad's second or third wife. That's where we're seeing, I guess, the reason why people are coming to us. There are these disputes regarding inheritance.
So, Kathy, I thought it would be good to understand some of the common causes of estate litigation. What are some of the themes that you generally see families fighting over, and what are some of the, I guess, like the legal aspects of those that families might need to consider now?
Yeah, the disputes generally form into one of two categories. The first category regarding the validity of the will, and this can be because either the will maker may have been elderly, may have had a medical condition such as dementia, and then the families are disputing as to whether that will maker actually had the capacity to make that will. We call this in legal terms testamentary capacity. And again, following on from what we've already said, there's often allegations of undue influence. So for example, when you've got an elderly parent, one child may be providing the majority of the caregiving to that adult, and then we find that when they've passed away, that child's receiving 80% of the estate, and the other two children, for example, are receiving 10% each. And there's a suggestion from the other two children that there's been undue influence, that they've potentially taken mum or dad to the lawyer, either prepped them, or if they haven't seen a lawyer, they've drafted the will themselves and got mum and dad to sign it. And in legal terms, that's called undue influence. The second category is when neither of those two situations apply. So it might be the case that the will maker had capacity, they were not subjected to undue influence, but they've still decided to leave their estate in their will unequally to their children. Or, as I've already spoken about, there could be a de facto and they've decided to leave it to the de facto and none to the children. The situation then kind of follows on, then the de facto potentially passes away and they don't leave anything to the stepchildren and it just goes to the children. In all states of Australia, we have legislation which covers this situation, and these are generally called family provision applications. So it's when the legislation does determine that not everyone can bring a claim just because they say, well, I should have got more from my dad or my mum's estate. It has to be a spouse, and that can be de factos or children. Children can be stepchildren, adopted children. So it does need to be one of those people, and they can then essentially go to the court and say, well, I should have been given more from the estate, and I want the court to order that there be, I guess, a change in mum or dad's will so that this is how much we all get.
I'm in the process of planning my estate and my will. What can I think of now to reduce the chance of my family fighting over my estate when I pass?
Well, it's great that the first thing that you're thinking about is your estate, and that's always the first thing we will suggest to anyone is you do need to think about it. You do need to have a will. Certainly it is a lot easier and a lot cheaper for your family when you pass away if you do have a will. So that's certainly the first step. The second step would be to make sure that that will is valid. And that's why we always say that you should consult a lawyer to get your will drafted. There are things that you might not think of that can have significant implications when you pass away. For example, you've done a will 30 years ago and you've forgotten about it, and your new will doesn't revoke the old one. we're then going to have a dispute as well, which one's valid because the new will didn't revoke the old one. Or for example, you might have got two of your beneficiaries to witness your will, and then you're going to have a complication because that's technically not a valid will. So that's why we say see a lawyer, get a will drafted and get it properly executed. But also following on from that, it's not just making sure it's drafted by a lawyer and getting witnessed properly. The matters that we've already talked about are things that a lawyer can assist you with. So for example, if you are older or you're assisting somebody who is older that needs to get a will drafted, if you go and see a lawyer, they can refer you to a medical professional to get an assessment and a report to say, yes, they've got testamentary capacity, yes, I'm satisfied that they can decide how and who to leave their estate to in their will. It might also be if there's any issues or questions about somebody's ability to read or to write English, that a translator can be arranged. So there's all of these things that you can do now to assist your family and to make sure that that kind of will is valid when you pass away. On a side note, it is also important to remember that not all of your assets will be distributed pursuant to your will. So you do also need to, at the same time as seeing a lawyer about your will, either get your lawyer or you can do it yourself, is to make sure that your superannuation, you have a non-lapsing binding nomination so that you can be certain as to where your superannuation is going to go, and just making sure any life insurance policies have updated beneficiaries. So again, because they might not be distributed pursuant to your estate, and you might have done those 20 years ago and they've either lapsed or you've separated from your husband or wife, or they've passed away and they're still named as a beneficiary.
Let's talk about what's in the estate and what's not in the estate, because I definitely got a surprise when I learned that my superannuation is not part of my estate. I wondered whether you could talk us through, for the average person, what they might start to think about when we put these boundaries around what's in your estate, but what's not in your estate that you also need to think about as part of your legacy planning.
Absolutely. Look, very important question to ask your lawyer if you don't know, because certain assets that are held jointly will not automatically form part of your estate. So for example, if you've got joint bank accounts and you might have a substantial amount in a joint bank account, that's automatically going to pass to the other joint owner of that bank account. Same with property. If you own that as joint tenants, that will automatically pass to the surviving tenant. And it is very difficult to know, because I know when you buy a house that it's not really something you think about of like, do I want my share to automatically pass to my partner or whoever I'm buying a house with when I die, or do I want my half or a different amount to pass to my estate? At the time of doing your estate plan, it is worth, if you're not sure, asking your lawyer to do a title search, and they can say, yes, this is how it's held, this is how it's not. And if that's not what you want, there are avenues to, for example, to sever a joint tenancy and to become tenants in common. So your half share will then form part of your estate. Similarly, like you've alluded to, is superannuation will not automatically form part of your estate. Previously, you could have binding nominations. Mostly they were lapsing. So after 3 years, you've done a nomination, you think your superannuation is going equally to your children, but that's lapsed. And it's now in the hands of the trustee of the super fund to decide, well, I might now pay it to your de facto, who you may not have had when you put that binding nomination in place. So it's good to revisit those nominations, make sure you have a non-lapsing one, making sure that your beneficiaries are current. And it's the same for life insurance policies. Again, will not automatically form part of your estate, so you need to make sure that your named beneficiaries are current and they're the people that you want your life insurance to go to.
So Kathy, back when we were talking about undue influence in estate planning, we mentioned testamentary capacity. I wondered if you could talk us through what that means and some of the parameters that we should think about.
Yeah, definitely. Look, testamentary capacity, it's just essentially that you have the ability to make a will. So to make a will, you need to understand firstly what a will is. You need to have an understanding of what your estate is. So for example, if you've forgotten that you own 3 properties, you're leaving all my real estate to my de facto, well then that's going to be an issue, because you firstly didn't really appreciate what your estate was. And thirdly, you do need to consider having regard to people who might have a claim on your estate. For example, that might be your de facto, whether they're a recent de facto, they've been your de facto for 30 years, your children, stepchildren, and making a decision on where your estate is to go when you pass away, having regard to all of those things. So I guess if there was a dispute as to the validity of your will, these are the things the court's going to want to know.
If I do all of these things, Kathy, if I have a lawyer draft my will, obtained a report from a medical practitioner as to my testamentary capacity, and I've explained why I've excluded one of my children from my will, have I done everything to prevent a claim against my estate, or will there still be some instances that I need to consider?
Look, this is a question we do get a lot. There is a misconception that if you leave a nominal amount to a beneficiary, that will prevent them from bringing a claim. Unfortunately, that's not the case. By doing all of these steps, it certainly does assist with testamentary capacity and undue influence. So ensuring, firstly, the first step that your will is valid has been met. The legislation in all states of Australia does, however, still permit, as we've talked about, either a de facto or a spouse or a child from bringing a family provision claim against your estate. So they can still bring that claim whether they've been left with nothing, they've been left with a nominal $1,000, 5%, etc. The amount they've been left does not determine whether they can bring a claim. They just need to be able to satisfy that category of people who have been named in the legislation as people who can bring a family provision application. Look, that said, the court does consider a number of factors when a family provision application is made. They'll have regard to the financial position of the child that's been excluded. They'll have regard to the health and the age and the future needs of that person, and then they'll weigh that up against the health, the financial position and the needs of the people who have been named as beneficiaries in the will. The court will also have regard to why has this person been excluded from the will. So was there estrangement? Were mum and dad not speaking to the child? And what was the reason for the estrangement? So sometimes if it's because of the child who has decided to have nothing to do with the parents, that's something that is important for the court to know. And obviously once you've passed away, you can't tell your side of the story. As you would expect in a lot of those situations, the child is going to say, well, it was entirely mum and dad, had nothing to do with me. The court shouldn't have any regard to this. So if you've chosen to exclude one of your children or give them a lesser amount because you may not have as close a relationship with that child, it is also important to potentially document those reasons why you've left them with a lesser amount. So documenting why you've left one of your children a smaller amount or excluded them from the will can be done in many ways. It might just be that it's in the will. It might be something more significant, such as an affidavit. But it's important that this is done. And again, you can do this with your lawyer, and this is going to be evidence that the court will have regard to when deciding how much of an estate, if any, to give to that person if they make a family provision application.
So how often should I be seeing my estate lawyer to make sure that my estate plan and my will are up to date?
You don't want to be thinking every second day about, is my will valid? But it is important, particularly at significant milestones or significant events of your life, to look back through your will. Is it still appropriate and valid? For example, have you left a property to a particular beneficiary that's now been sold? Or have any of your children had children and you now want to leave things to the grandchildren? Or has your spouse passed away? So we always say any significant event in your life, and it might be that you don't change your will, but it's worth just having a look at it, saying, is it still current? Does it still leave my estate to who I want it to go to? And again, at the same time, always again double checking your life insurance and your superannuation and any assets that are jointly owned. Am I still comfortable with them going automatically to that surviving joint owner of that asset?
And we find that families who do have open communication around what their intentions are with their estate, having accurate records of what's in the estate, what's not in the estate, in an easy to read format and in an easy to find location, goes a long way to mitigating family and relational breakdowns. But I just wondered, from your perspective as an estate lawyer, how often should we be thinking about keeping our family in the loop, and what information do our family really need to know?
Look, the first thing to note is that you don't have any obligation to provide a copy of your will to your family. That said, we do find that family members can be more upset at finding out they've been left out of a will when they're provided with a copy after you've passed away. It's always up to the individual, and for the individual to have regard to the relationships that they have with their family members, and if they want to disclose it ahead of time. The points you've made about making sure all of your information is up to date, whilst that doesn't alleviate, I guess, some of the issues I've talked about of testamentary capacity and family provision applications.
Yeah.
It does make the process smoother for whoever is administering your estate if they know what assets you had, where the assets were held. One of the other things that I don't think we've spoken about is a lot of people do choose to separately to their will have a list of items of nominal value that they wish to go to certain beneficiaries. So this can also be of assistance, because you'd be surprised how many times people are fighting over things that really have no value. They just want a reason to fight. So it might be that you have a list of everything in your, it might be showing my age, of your crystal cabinet of where all of the things that you've collected over your lifetime are going to go. This certainly does assist with those, I guess, those family relationships.